Good morning and welcome to SIROHI law classes. Today, before we start, I would like to introduce myself, UK SIROHI, a judge from the state of UP. Today's topic for discussion is Section 8 of the Indian Evidence Act. Section 8 of the Indian Evidence Act talks of motive, preparation and conduct of the parties as relevant to a fact in issue. What does it say? That when the motive is an important element in crime because it sometimes lead to discovery of the intention. To find out the intention, being the mens rea for a crime, we take help of the motive. Motive is something which prompts a man to form an intention, means the ulterior motive behind the doing an act. So, in quest for finding out the intention, we have to look upon the motive part also. So any fact which throws a light on the motive, any fact connected with the motive, whether he had or not having any motive, would be a relevant fact. So where the motive can be found out? Motive, since it's a mental element, it might be in the mind of the accused, but the circumstances around the accused and the victim will throw the light upon whether the accused would have any motive or would not have any motive. So all such facts which have a direct relationship, the motive would be the relevant fact and the evidence would be admissible of such facts. After intention, motive, then intention, the next stage in commission of the crime is the attempt. Before attempt, it is the preparation. So any fact which is directly connected with the preparation, assembly of the weapon, creating occasion to commit the crime, would also be a relevant fact. Suppose A wanted to kill B, and for that purpose he procured a revolver and hide it in the house. So also procured the cartridges and whatever the means may be. He might have required a car or the bike to commit the offense. All these acts are connected with the preparation, and the preparation in itself is not an offense except with few exceptions like sedition and waging war against the state and the preparation to commit the dacoity. So in general, preparation is not punishable per se. So any fact which throws light on the accused preparation part would also be a relevant fact under section 8 and will be admissible as evidence. Another part which section 8 covers is the conduct of the parties. Important to note, the conduct of the parties means the conduct of the accused, conduct of the deceased, but not the conduct of the third parties, strangers, witnesses who might have been present at the scene of the crime. As you know that under section 6 res gesti, whatever is said, done at the time of commission of a particular transaction, for example a crime, whatever is said and done by the accused, witnesses, victim, all are relevant, provided they all have been said or done in course of one transaction. The principle of the separability applies, that the acts were not separable. So in one transaction, for example, A shoots B by firing a revolver. Whatever A said I will finish you right now. He ran away towards the B. All these acts are part of the same transaction, and then A fired at B. Then B tried to escape and save himself. Also said something, save me, cried. So, and witnesses, third parties also intervened. See what is happening, stop, whatever is the scene of the crime. All these events would be relevant as res geste under section 6. But what to do the previous conduct and the post conduct of the parties of the witnesses over there? Means the conduct which is outside the scope of the section 6 res geste, previous conduct and the post conduct. Important to note is that here under section 8 the conduct of the parties is relevant, not the conduct of the third parties. There is only one situation where the conduct of the third party, a stranger, like for example a witness, would be a relevant fact if the act of this witness affects the conduct of the parties. Only in that scenario the third party conduct would be admissible under section 8. Otherwise section 8 is strictly confined to the conduct of the parties. Explanation 1 of section 8 makes a peculiar gives a peculiar scene where the act is accompanied by an oral statement. Here under section 8 only conduct would be admissible, but what to do when such act was accompanied with an oral statement? Suppose this man ran away after getting the bullet injury, saying something, or let the accused ran away after injuring the victim, and while he was running or saying something which was not the part of the res geste, which is a separate incident having some time gap and interval, what to do when he also say something? He is running, suppose accused is running from the scene. कोई बात नहीं, आज बच गया, अगली बार नहीं छोड़ूंगा. अब he is running. So where this statement, oral statement would be admissible? So explanation 1 covers it. When this previous or the post conduct of the accused or the victim is accompanied by an oral statement, then oral statement would also be admissible as his conduct under section 8, because the conduct which is certainly relevant cannot be separated. What he did, what he said, what oral statement he made while doing that conduct which is admissible. So in that case the conduct, not only the conduct, the overt act, but also the oral statement, whatever he has said, would also be relevant fact. Hope you might have understand it. Thank you.